strategic and tactical win on your part, don't you think?
Depends. At this point, knowing what we know about Rosa Lopez, we want them to call her, so
Well, then maybe you should subpoena her.
maybe we will. In any case, Your Honor, yes, I'm sure that's been a great burden to the defense. Got 4 millionaires over here paying, what, 100 a night? Anyway, when we visited this issue after opening statements, we saw them argue to the court that everything was taken care of, and now we're hearing the same argument again. No, I can't believe that that anybody buys this anymore. Certainly, the people do not. They argue vehemently that a sanction should not redound to the detriment of the defendant. It doesn't. It redounds to the detriment of the witness. Given the fact that under our discovery laws now, the court is well within its authority to preclude the introduction of evidence altogether, to deny them the right to call a witness altogether, it is clear that allowing the people, and the people haven't even asked for preclusion, although we would be well entitled to at this point, all we're asking from the court is the admonition to the jury and the ability to argue what is a clear pattern of conduct by the defense. Because this is a sinister scheme. This is a conspiracy. You know, they are trying to hide the ball. They are trying to prevent the jury from hearing what the witnesses are really about and from hearing the truth. And I think that, at the very least, the people should be entitled to argue that fact, to say this witness was withheld.
All right,
This statement.
Do you recall the instruction that I gave to the jury before I allowed you to reopen? That the jury can take into consideration the impact of the delay on the credibility of a witness, if any.
Mm-hmm.
However, as Mr. Ullman pointed out, the case law that deals with the jury instruction regarding the fabrication and manufacturing of evidence, the hiding of evidence, there must be a direct link to the defendant as authorizing that conduct before I can give that instruction.
No, as I understand it, Your Honor, that's not the same instruction, though. We're
No,
asking
but
for
certainly it's analogous.
I don't think so.
Delay in disclosure and willful non-disclosure. In any event, something to think about.
Yeah,
All
and
right.
obviously the court would like if the court would like, we would draft an admonition for the court's
I
review.
think I've already done something about delay of disclosure of witnesses or information regarding witnesses, haven't I?
You mean in the
Something
opening
pretty close,
statement?
yes. All right, Ms. Clark, do you have any other comment?
Yes, specifically this, Your Honor. Mr. Douglas again indicates a lack of understanding of the law of discovery when he indicated today that any reports that were generated solely for impeachment are not discoverable. That's not correct. That is not the law. Under Izazaga, reports on impeachment are discoverable if they contain witness names or statements that are to be introduced in rebuttal. Only if the defendant goes back and re-interviews a witness the people have provided and gets an inconsistent statement is that not discoverable. So just so we're clear on that. With respect to then...
I think you're referring to, what is it, footnote 7 and
Is it footnote 7?
14.
Footnote
And then
14.
Yeah. One's a path,
One of those,
we know,
yeah.
the dog-eared pages we all have.
14, footnote 14.
I think it's really interesting, too, that counsel now attempts to expand the circumstances under which Mr. Pavlik will tape to include being female. What is it about being female that requires us to be taped, I'd like to know. And I'd like to have Mr. Pavlik under oath and ask him those questions, too. I really want to know about that one. Nevertheless, Mr. Pavlik himself, when questioned, indicated that the criteria he used was that he was alone and without a partner. And that's a nice gender-neutral reason that I think makes sense. However, we have to find out if that's true, because if that's true, there are a number of witnesses that he refers to as having interviewed alone, and we have no tapes for them. And if the court would like, I can read those names into the record.
Please.
Ms. Lynette Goldner, Goldner. Ms. Cassandra Ahern, Ahearn. Mr. Thomas Talarino, Talerino. Mr. Richard Aaron, Aaron. Mark Partridge, Ronald Taylor, Taylor, Steve Valerie, Valerie, for whom we have one statement on June 23rd and another one on June 17th. Howard Bingham, Bingham. Richard Walsh, Walsh. Tony Valenzuela, Valenzuela. Mr. Ed McCabe, Mccabe. Bethy, Bethy, Vaccarano, Vaquerano. Ms. Kay Bell, that's K period. Mr. Jason Wood, Mr. Tony Parker, Ms. Rachel Berman, and her mother Pat Berman, and her father Mr. Berman, and Michelle Abudram, Abudrahm. All of those were indicated by Mr. Pavlik as having been interviewed by him alone. And we would like for the court to inquire of him under oath as to where the tapes are that should exist of those interviews. 20. Those are 20 witnesses.
All right. Any other comment, Ms. Clark?
Thank you, Your Honor.
All right. All right, thank you, counsel. Due to the lateness of the hour, I'm going to take the motion for sanctions and further discovery orders under submission at this time. I'll issue a written ruling on this matter as well. And Mr. Douglas, you had asked for a 1054.7 in camera. I'm going to continue that over till tomorrow morning at 8:30.
That's fine, Your Honor.
All right, I'm going to order you to be here. I'm sorry. 8:30. All right, I have another sentencing matter at 8:30, but be here at 8:30. All right, counsel, anything else before we stand in recess? All right, Ms. Clark, are you aware of any reason why we can't go forward with the 1335 tomorrow morning?
I haven't heard anything, so I'm assuming we will be ready to go.
All right. Anything else, counsel? All right, tomorrow morning, 9 o'clock. And Mr. Douglas, 8:30. All right, thank you, counsel.